the case exists. It's absolutely there. There's 100 citations, there's articles about it, there's everything. It's just the LLM misrepresents what the case actually says.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Our second hallucination type is distorted holdings. Right, you want to walk us through that?
Yeah, so distorted holdings is a situation where the cases are real. The LLM sets a real case, but misrepresents what the case means. A classic example for our industry, we had the famous Obdusky case, the one that talked about whether or not a law firm is a debt collector. I believe this one went all the way to the Supreme Court. But it is very easy if you're a law firm in our industry and you go into any of the LLMs and you say, hey, am I a debt collector? The LLM could come in back and say, yes, you are, or no, you're not, without explaining to you the specific details of Obdusky, where they actually separate between a judicial foreclosure and a non-judicial foreclosure. And so if I go into the LLM and I ask, hey, should we comply with the debt collector requirements? And the LLM comes back and says, no, you're a mortgage default law firm, and cites Obdusky, that's a real case. I can verify that the case existed, but it's reading it wrong. The LLM's understanding of the case is wrong. And that is, again, a hallucination, but it's a lot harder to find. If I do the cursory check that we talked about in the last example, yeah, the case exists. It's absolutely there. There's 100 citations, there's articles about it, there's everything. It's just the LLM misrepresents what the case actually says.
Do you feel like this is life? Our LLMs are going to read things wrong?
Yes. Unless you tell them interpretations, I think they will come up with their own, and they're not always going to get it right.
I find you can't just say, what's the holding, or give me cases that have that holding. It'll give you cases, right? What I would suggest, or what I think would be appropriate in a situation like this, is you have to build more slowly. So step one is, here's my case. Here's my theory of the case. Here's how I'm seeing this should play out. What types of arguments do you think I need? It then gives you a list of arguments you think you need. And I would say, well, I think 6 of these arguments, based upon the facts that as I know it, are not going to work for me. Let's work on these other 4. Now, within those 4, show me the 50 cases you like for each one. Go crazy. Give me all of them that are appropriate. Put like a 2-sentence holding next to all of them, right? And then you dig in further and you're like, I want cases that apply it this way, or in this district, or in this jurisdiction. And as you whittle it down more and more, I can't say you won't still have a distorted holding. I'm just saying that I think that if you go through it more like that and you put in the time and you use it with that type of specificity, I think the likelihood of the LLM leading you down a path where it is totally misunderstood the case is much, much more unlikely. You have to still check the case? Yes. To me, this problem is because attorneys are looking to do their work faster. These programs are incredibly effective at helping you do your work better. And when you're just trying to go faster, you have a big problem. When you're trying to do it better, you might put in the same amount of time. You might put in more time, right? It might be hands off though, because you do it in voice memos, whatever you want to do. But you could do it much better. And I think that part of the issue here is we're trying to go faster.
I completely agree with you. And I think even when I'm building a policy, even when I'm writing a document, I don't know that using AI actually saves me time. It makes it a lot better. The work product is a lot better, but I probably spend as much time, if not more sometimes, because of the iteration, because of the back and forth. I think the reason distorted holding is important is because if we talk about Joe Attorney, who is well aware of the fabricated citation issue and believes that's the hallucination, and they go into a brief that the AI generated for them, and they look at it and they just confirm that that citation exists, that case is a real case, and they move on, and they don't check oh, what does that mean? What is the actual explanation? What does the case stand for? They won't think to do that because in their mind, oh, it's a real case. The AI got it right. Now, I think the other aspect of distorted holdings that we need to think about is there are a lot of instances in our universe where there are specific decisions by a specific court, and then they get interpreted by other courts, by other decisions. They fine-tune it, they explain it, they give you more details on it. So citing the first case sometimes doesn't give you all that information because the AI has no idea those other cases even exist. And I think it all goes back to what you said. You have to put in the time. AI is not a shortcut. It will not do things for you faster. And if it will, it probably is not going to do them well. But if you put in the time, if you go in and read it, if you understand it, then you get much better quality of work.
stay tuned to our channel for part 3 of this conversation coming soon.